Okay. All right, tell me when you're ready. All right. Test, test. Test, test. Test, test. It's good?
Good morning, everyone, and the hearing will come to order. Before we begin, I would like to ask unanimous consent that Chairman Rowe be allowed to sit at the dais and make a statement and ask questions. He's not here right now, but he will arrive soon. Hearing no objections, so ordered. Thank you all for joining us today to discuss legislation before the subcommittee. The 7 bills we'll talk about today address issues that are very important to veterans and their families. These bills would include and involve issues, things that ensure veterans' benefits keep pace with inflation, require VA to accept private medical evidence, extend benefits to the Blue Water Navy veterans, protect vulnerable veterans from fraud, give families more choice to decide where to lay their loved ones to rest, and clarify that VA may use mandatory funds to pay the cost of traveling to contract disability examinations. We've got a full agenda today, so to ensure that we get through it all, I'm going to ask everyone to keep themselves to 5 minutes. I heard another chairman say the other day that we'll refer to that as the bull riding rule. So if we'll let you go, and the buzzer rings at the 5-minute mark. You got 8 seconds, and then we're going to throw you off. So, any rate, I would like to start today with the 2 bills that I'm proud to have introduced: H.R. 1328, the American Heroes COLA Act of 2017, and H.R. 1329, the Veterans Compensation Cost of Living Adjustment Act of 2017. I also want to thank Ranking Member Esty for being an original co-sponsor on both of these bills. H.R. 1329 would give a cost of living adjustment to veterans. This increase would be the same as Social Security recipients get and would help veterans keep up with inflation. Of course, H.R. 1329 has my full support, as it should. I have also introduced H.R. 1328 to ensure that veterans will receive a COLA every time Social Security recipients get one. Veterans have earned these benefits and should have the peace of mind of knowing that they will receive a COLA every year without having to wait for Congress to act. I know many of my colleagues here today have worked hard on these proposals, and I look forward to having a constructive conversation. I also want to thank our witnesses for testifying on these important bills. I'm going to turn it over to my colleague, Ranking Member Esty, for her opening statements.
Thank you very much, Mr. Chairman, for holding today's hearing on behalf of our nation's veterans. Today, we are examining 7 bills that are of vital importance to our veterans and their families. I support them all, and am proud to have worked with the chairman to introduce, as he has just noted, H.R. 1328 and H.R. 1329, the American Heroes COLA Act of 2017 and the Veterans Compensation COLA Adjustment Act. These are bills that ensure that we are keeping faith with our veterans and keeping economic pace with the reality of what things cost in America today. So I urge my colleagues to listen attentively to our witnesses and to support these important bills, which will make sure that our veterans with service-connected disabilities and surviving spouses of veterans receive dependency and indemnity compensation that is appropriate. It's simply the right thing to do. We are also considering H.R. 1725, the Quicker Veterans Benefits Delivery Act, and it's an important part of today's agenda. This bill, which is introduced by full committee Ranking Member Waltz, speeds up the benefits delivery process by allowing local physicians to conduct disability medical examinations for veterans. I am sure everyone on this panel and everyone in this room has heard extensively about this issue from the veterans we are honored to represent. Specifically, the bill provides that when a claimant submits private medical evidence that is competent, credible, probative, and otherwise adequate for rating purposes, the Secretary will not request a VA medical examination. Also on today's agenda is H.R. 105, the Protect Veterans from Financial Fraud Act, introduced by our colleague on the subcommittee, Julia Brownlee. It protects veterans from the misuse of their money by a fiduciary by expanding the Secretary's authority to pay recompense to a beneficiary that has been a victim of fraud. H.R. 299, the Blue Water Veterans Navy Vietnam Veterans Act is brought forward by Representative Valadao, who I see has already joined us and is on the first panel. This bill enjoys broad bipartisan support from this Congress, and I will say I am strongly supportive, have many veterans in my district who have spoken to me repeatedly about this issue. It expands the compensation and health care benefits to veterans who served off the coast of Vietnam during the Vietnam War and who have manifested the statutorily defined diseases related to exposure to herbicides used in Vietnam, such as Agent Orange. As all of us know, currently only veterans who have served on land are eligible for the presumptive connection to herbicide exposure. As this group of bills moves forward towards a subcommittee markup, I want to thank all the members for their thoughtful legislation, and I want to thank all of our witnesses for joining us today, as well as for your work with us on these bills. I look forward to hearing your testimony. Thank you, and I yield back.
And to thank the ranking member. I look forward to working with her on these issues as we move forward. And I want to let you know that I'm honored to be joined with Mitt this morning by several of my colleagues who are going to testify about the bills on our agenda that they have sponsored. I appreciate all of you taking the time out of your morning to be here with us for sponsoring legislation to help the veterans. With us this morning, we have Representative Jim Banks from Indiana, Representative Jack Berkman from Michigan, and Representative David Valadao from Florida. We believe that we will have a representative from California. Sorry. That's all right. Bob Dole did that. Representative Julia Brownlee will be joining us later also. I also understand that Ranking Member Waltz wanted to be here today but had a scheduled conflict. I'm asking unanimous consent that his written statement on his bill, which was noticed for this hearing as a draft bill, H.R. 1725, the Quicker Veterans Benefit Delivery Act of 2017, would be admitted in the record. Hearing no objection, so ordered. Mr. Banks, first off, you are recognized for 5 minutes to discuss your resolution, your bill.
Thank you very much, Mr. Chairman. In addition to ensuring that our veterans receive the benefits that they have earned, this subcommittee is also tasked with ensuring that our nation's heroes are treated with reverence after they pass. Currently, the VA only covers the cost of transporting a veteran's remains to a national cemetery, but does not pay burial transportation costs to a state or tribal veterans cemetery. H.R. 1390 would correct this problem and allow the VA to pay the transportation cost regardless of whether the veteran is buried in a national, state, or tribal veterans cemetery. By doing so, this bill would provide more options for families who are deciding where to lay their loved one to rest. A family may prefer to bury a veteran in a state or tribal veterans cemetery because it is closer to home, which would allow the family and friends to visit the grave and pay their respects. The bill would remove the financial penalty if a family chooses to inter their relative in a state or tribal veterans cemetery instead of a national cemetery. It is incumbent that our nation never forget the sacrifices our veterans and their families make each and every day. One way we can honor their service is to ease the burden of a grieving family deciding where to lay their loved one to rest by offering them more choices. I ask my colleagues to join me in supporting H.R. 1390, and I yield back.
Thank you, Mr. Banks. I'd like to recognize Ms. Brownlee for 5 minutes on her bill. Welcome.
For considering my legislation, the Protect Veterans from Financial Fraud Act, which will ensure that our veterans receive the benefits they have earned and deserved. As many of you may recall, my bill passed the subcommittee in the 114th Congress, but was not brought to the floor for a vote. I'm hoping that we can get a home run this year and appreciate that the subcommittee is holding a hearing on the bill. As you know, the VA's fiduciary program was established to protect veterans and other beneficiaries who, due to injury, disease, or old age, are no longer able to manage their financial affairs. Many veterans who participate in the fiduciary program depend on their VA benefits truly to make ends meet. In fact, in 2016, the fiduciary program served more than 230,000 veteran survivors and dependents. My bill would protect veterans in the fiduciary program from financial fraud by ensuring that every veteran in the program can recover their benefits in cases when the appointed fiduciary misuses or steals a veteran's benefits. Under current law, if a VA-appointed fiduciary misuses or steals a veteran's benefits, the VA has the power to remove the fiduciary, and we know this is a serious concern. In 2016, the VA conducted nearly 1,500 misuse investigations, of which 764 fiduciaries were removed based upon a finding of misuse of benefits. However, in many cases, VA can't reissue the benefits to the veterans who, through no fault of their own, may have been swindled by a VA-appointed fiduciary. This is because the VA can only reissue the lost benefits to the veteran if their fiduciary manages VA benefits for at least 9 other veterans. This arbitrary 10 or more rule means that veterans cannot be made whole even if the veteran has been taken advantage of by unscrupulous individuals, often those closest to them, who were entrusted with management of a veteran's finances. My bill will ensure that all veterans who have VA-appointed fiduciaries are treated equally by eliminating the 10 or more rule. And my bill will ensure that all veterans who have their benefits stolen can recoup the lost benefits. I'm pleased to see from the testimony that the VSOs here today are supportive of this change, and I'm glad to hear that the VA also believes Congress needs to fix this statutory problem and allow the agency to make all veterans whole. The VA and our VSOs agree that the existing law is arbitrary because it forces VA to treat 2 beneficiaries differently and does not provide the same financial protections to all veterans. My bill will correct this injustice. Every veteran participating in the VA fiduciary program should be fully protected from fraud and abuse. I urge my colleagues to support this simple, common sense fix, and am happy to answer any questions.
Thank you, Ms. Brownlee. Representative Berkman, you are recognized for 5 minutes.
Thank you, Mr. Chairman. My bill is very simple. It would clarify that the VA has the authority to use mandatory funds to pay for the cost of veterans' travel to contract disability examinations. As you know, a veteran who files a claim for disability benefits may be required to undergo a VA medical examination. However, VA does not have enough examiners to schedule these evaluations in a timely manner. It can be especially challenging for VA to arrange for disability exams if the veteran needs to see a specialist, such as a cardiologist. Furthermore, veterans who live in rural areas often have to travel long distances to get to VA facilities to see an examiner. To address this issue, Congress gave the Department the authority to contract with non-VA physicians to perform disability examinations. This policy also allows VA physicians to devote more time to care for our wounded heroes rather than spending time conducting disability exams. Additionally, using contract examiners has the added benefit of helping VA to schedule disability evaluations closer to the veteran's home. For more than 20 years, VA has been paying for beneficiary travel regardless of whether veterans who needed disability evaluations use VA facilities or contractor facilities. This bill would simply codify VA's long-standing practice of using mandatory funds to pay beneficiary travel for contract exams. H.R. 1564 does not add to the deficit because this money is already included in the baseline. This legislation will help veterans receive the benefits to which they are entitled by allowing VA to pay beneficiary travel to contract disability examinations. I ask my colleagues to join me in supporting H.R. 1564, and I yield back.
Thank you, Mr. Berger. Our colleague, Mr. Valadeo from California, is at the witness table. First off, thank you for being here and to discuss H.R. 299, the Blue Water Navy Vietnam Veterans Act of 2017. Mr. Valadeo, you're recognized for 5 minutes.
Thank you, Chairman. Chairman Boss, Ranking Member Esty, members of the subcommittee, thank you for allowing me here today to offer testimony on my legislation, H.R. 299, the Blue Water Navy Vietnam Veterans Act. Since coming to Congress, I've been a proud supporter of our nation's veterans, and I'm excited to sponsor this critical legislation today. The members of this distinguished subcommittee have a comprehensive understanding of the harmful effects of the herbicide Agent Orange and a lasting impact it has had on U.S. service members who sacrificed so much for our country during the Vietnam War. Our government must now ensure that those who are exposed to Agent Orange during wartime are provided for when they return home. In the aftermath of the Vietnam War, the United States government linked the chemical dioxin in Agent Orange to many harmful and serious medical conditions affecting those who served in or around Vietnam. While the federal government has provided for those who served on Vietnam soil during the war, those who served in territorial seas of the Republic of Vietnam lack the compensation and treatment they deserve. In 2002, the Department of Veterans Affairs reinterpreted the language of Agent Orange Act of 1991 to apply only to veterans who actually set foot in the Republic of Vietnam or who served in the inland brown waterways. As a result, the veterans who served off the coast in blue water must now prove service connection and exposure to Agent Orange, which can often prove a long and burdensome process. The VA continues to deny claims for Blue Water Navy's veterans, despite studies that show higher rates of cancer and non-Hodgkin's lymphoma among shipboard veterans. While it may be difficult to definitely prove the Blue Water Navy veterans were exposed to Agent Orange, their higher rates of diseases associated with exposure to the herbicide are cause for alarm. This, combined with studies to show a plausible pathway for the herbicide to have entered the South China Sea, are evidence enough that these brave service members were exposed to the herbicide. Even more alarming, studies also show the distillation process to convert salt water to drinking water enriched the chemical dioxin in Agent Orange's potency and contaminated the shipboard water system. My legislation, H.R. 299, the Blue Water Navy Vietnam Veterans Act, would restore the presumption of service connection for Blue Water Navy veterans that existed prior to 2002 VA decision. Lifting the burden of proving service connection from the individual veteran is vitally important as it places Blue Water Navy veterans on the same playing field as those who served on land. These brave men and women of our nation's armed forces have sacrificed their health and oftentimes their lives in service to our great country. Providing for them when they return home is the least we can do to show our unwavering commitment to our veterans and appreciation for their service. Along with myself and my co-lead, Ranking Member Tim Walz, this legislation has the support of over 250 members of Congress and counting, including 16 members of the Veterans Affairs Committee. It is important for Congress to ensure our Blue Water Navy Vietnam veterans receive the support and care they need. I thank the Subcommittee on Disability Assistance and Memorial Affairs and the Veterans Affairs Committee as a whole for their consideration of this critical legislation, and I hope that we can work together to provide for our nation's heroes. Thank you.
Thank you, Mr. Valadeo. And we will forego any rounds of questions for Mr. Valadeo, and any questions that anyone may have for our colleague may submit them to the record. I now want to invite the second panel to the table. We're joined today by Ms. Beth Murphy, the Director of Compensation Services at the Veterans Benefits Administration. She's accompanied by Ms. Patricia Watts, the Director of Legislative and Regulatory Services for the National Cemetery Administration, and Mr. Ralph Erickson, the Chief Consultant for Post-Deployment Health Services at VHA. Thank you for being here, and Ms. Murphy, you are recognized for 5 minutes.
Good morning, Chairman Bost, Ranking Member Esty, and members of the committee. We appreciate the opportunity to be here this morning to present views on several bills that would affect VA programs and services. The first bill I will address is H.R. 105, Protect Veterans from Financial Fraud Act of 2017. This bill would remove restrictions on VA's authority to reissue benefits in cases of fiduciary misuse. Also, it would codify current policy that mental competence determinations are appealable to the Board of Veterans' Appeals and U.S. Court of Appeals for Veterans Claims. VA supports this bill to ensure equal treatment of all fiduciary misuse victims and allow VA to promptly reissue benefits, thereby minimizing financial hardship to beneficiaries. H.R. 299, Blue Water Navy Vietnam Veterans Act of 2017, would extend the presumption of Agent Orange exposure to all veterans who served on ships in the territorial seas of the Republic of Vietnam. VA has concerns with H.R. 299 and cannot support the bill at this time. The bill does not clearly define the terms territorial seas. VA is also concerned with the September 25, 1985 effective date of the bill, which would potentially result in many cases with retroactive awards of more than 30 years. Readjudicating old claims and establishing large retroactive awards would be complex and labor-intensive and divert resources from other disability claims. Lastly, there is continued scientific uncertainty surrounding this issue. At VA's request, the Institute of Medicine reviewed all scientific evidence and could not state with certainty that Blue Water Navy personnel were or were not exposed to Agent Orange. VA continues to review and monitor available scientific evidence on this issue. H.R. 1328, American Heroes COLA Act of 2017, would permanently authorize VA to implement cost of living increases to rates of disability compensation and dependency and indemnity compensation, or DIC. VA supports this bill, and this is consistent with the longstanding practice of Congress to enact regular cost of living increases and would eliminate the need for additional legislation to implement such future annual increases. H.R. 1329, Veterans Compensation Cost of Living Adjustment Act of 2017, would require VA to increase rates of disability compensation and DIC by the same percentage as any increase to Social Security benefits effective December 1st, 2017. VA strongly supports this bill to ensure the value of benefits keeps pace with the increase in consumer prices. H.R. 1390, Transportation of Deceased Veterans to Veterans Cemeteries, would increase burial location options for which VA may pay transportation costs for eligible veterans' remains. VA supports H.R. 1390 because in addition to national cemeteries, VA would also pay transportation to veteran cemeteries owned by state or tribal organizations. Next, H.R. 1564, VA Beneficiary Travel Act of 2017, would direct the use of funding from the mandatory compensation and pension appropriation to pay for travel and incidental expenses associated with contract disability examinations. VA strongly supports the bill that would codify clearly authorizing VA to fund the nationwide contract exam pilot program from a single source. Finally, H.R. 1725, Quicker Veterans Benefits Delivery Act of 2017, would prohibit VA from requesting a C&P examination when a claimant submits medical evidence adequate for rating purposes and would require VA to report on the progress of VA's Acceptable Clinical Evidence, or ACE initiative, and submit data for each VA regional office on use by claimants of private medical evidence in support of C&P claims. VA does not support this bill, but appreciates the intent to more expeditiously provide benefits to veterans. However, VA currently has a policy of adjudicating claims without a C&P exam if a claimant submits evidence adequate for rating purposes, even from private providers. This practice is grounded in existing statute and VA regulation. VA is especially concerned with the reporting requirements of the bill. VA tracks the number of ACE exams, but does not track when evidence is supplemented with a telephone interview or when private medical evidence is or isn't sufficient for rating purposes, as this is not a formal determination. If a CFP exam is requested after receiving and reviewing private medical evidence, VA has determined in its claims adjudication process that the evidence is insufficient for rating purposes. This concludes my remarks. I would be happy to answer any questions you may have. Thank you.
Thank you, Ms. Murphy, and thank you for testifying before us today. I'm going to go ahead and go to questions, and I'll have the first 5 minutes. Ms. Murphy, can you elaborate, please, on the importance that Congress passed House Resolution 1329, that's the Veterans Compensation Cost of Living Adjustment, and why do you think that that's necessary and you're in support of it?
Mr. Chairman, thank you. This makes good business sense. It's great for veterans. It makes sure that we keep pace with the economy and make sure that their benefits maintain viability with consumer pricing. Also, I would tell you behind the scenes there is some work that has to be done to make those adjustments in our systems every year, and when we're waiting up to the minute sometimes for that thumbs up, it gets a little challenging. So this would just make sure that cost of living adjustment was in place and ensure veterans the confidence that we want to make sure that their benefits remain viable.
Well, the next question is similar, but going to the next bill, and that is, what do you think of when House H.R. 1328, forgive me for the House resolution, that my Illinois side that keeps coming back on that instead of H.R. 1328, would provide veterans and some peace of mind, and to having that COLA so they know that it's going to occur. With your dealing with veterans, what do you think, one, is what is our reaction, your reaction, and then the reaction that you think we would get from veterans?
I think it's a win-win. We would certainly support it. It's something that we anticipate every year and plan for that, but just knowing that it will be in place and that it's not something we have to wonder and guess about provides confidence for us, provides confidence for veterans, and honors their service to make sure that they understand that their benefits are important to them and they're important to us as well, and that we want to make sure they keep pace with economic pricing.
Yep. My next question is for Dr. Erickson. Dr. Erickson, in the past, VA has stated that one of the reasons it has been hard to determine whether Agent Orange presumption should apply to Blue Water Navy veterans is the lack of measures taken at the time of the potential exposure. What efforts has the department done, have they put in place now to maybe adjust that?
Thank you, Mr. Chairman. Just by way of introduction, I'm a veteran as well. I served for 32 years of active duty as an Army doctor. My last assignment was as the commander of the Walter Reed Army Institute of Research. Been with VA for now 3 years. We recognize that short of inventing a time machine to be able to go back to get those measurements that we don't have in this case, we're being prospective. And so we're actually partnering with the Department of Defense to create something called the Individual Longitudinal Exposure Record, the Individual Longitudinal Exposure Record, or the ILER for short. This is a fairly large task that we're undertaking that will allow the Department of Defense to actually collect real-time exposure measurements on service members during their time of service. And this would be information that would be available then to healthcare providers while that service member is still on duty, and afterwards to providers who are within the VA system. We think this will take us a long way forward and will correct a major gap right now that we have to deal with.
So what you just said is that you do have the research available to go back and actually identify those Blue Water Navy veterans and truly see and studies have been done?
No, sir, we don't have the ability. DOD does not have the exposure information. VA does not have the exposure information for Blue Water Navy, but from today into the future, for future service members, we're actually trying to correct this, realizing that we didn't do this on a corporate level within DoD or VA for past cohorts of service members, but from here on out, we're working with the Department of Defense to make sure that happens.
Okay, Ms. Murphy, one more question for you, and can you please expand on why the VA extended the presumption of exposure of the Agent Orange to brown water Navy veterans, but not blue water Navy veterans?
So I will ask Dr. Erickson to supplement any science on this, but essentially, those that had boots on the ground in Vietnam and those in inland waterways share a commonality in the types of exposure, extent of exposure that they would have been experiencing, which is differentiation from the amount or types of exposure that they would have had out in the blue water. Dr. Erickson, can you supplement with the science behind that? Yes.
Certainly. I think it was based upon the fact that we knew that spraying had occurred along the coasts, in fact, included spraying by riverine vessels that would be going in and out of the rivers and the openings for those rivers. And so there was a fairly strong basis that, in fact, the Agent Orange had been sprayed at those locations.
Okay. My time's expired. I would like to turn the question now over to the ranking member, Ms. Estes.
Thank you, Mr. Chairman. If I could follow up, Dr. Erickson or Ms. Murphy, on would it be helpful for us to be more specific on territorial seas? Certainly there was some discussion, and I am hearing from veterans who I represent, and the mechanisms, maybe Dr. Erickson, for you, about the concentration, the desalination, and do we really know how much exposure there was? Because that's what I'm hearing. I have to tell you, frankly, that's what I'm hearing a lot about, and I'm not sure that there has been sufficient attention paid to what that exposure might have been.
So, Congresswoman, yes, there's some uncertainty in what the definition of territorial seas is. It's one of several factors that I mentioned that causes concern with the bill.
Would more specificity help? I mean, because we are facing situations in which we have veterans now, and as you point out, 30 years on, well, it's hard to prove retroactively, but let's be very clear. We sent them into harm's way, and they are now experiencing exactly the same symptoms and problems that their colleagues, men and women in arms, were facing on land. And you can understand our frustration and theirs, and saying, like, we don't know enough yet. It's 30 years. You can understand there might be a little bit of cynicism about maybe we'll decide at a point when it's no longer possible to help anybody.
I can absolutely understand the frustration. I've committed my whole career to serving veterans and finding ways to pay benefits. And to do that, we have relied on the fact that there needs to be a rational basis for additional benefits and legislation that regulations that we add in to pay benefits. And we've been searching for that with Blue Water Navy veterans and broader types of veterans to find benefits when there's no rational basis or no science behind it that we can put our finger on. So it's something that we continue to look at. We've not had full opportunity to discuss this with the Secretary. He's new, and he is a physician and understands these issues and has a different perspective, possibly.
Well,
so this will continue. This
Okay, great. I've got some other questions. So,
Yes.
Dr. Erickson, can you speak to a little bit to the desalination issue?
Certainly. Ranking Member Esty, you've asked perhaps the central question. And we mentioned in our written testimony that there is uncertainty, and there is tremendous uncertainty. We very much respect our Australian partners who have gone to war with us so many times. We respect the scientists who, in fact, did a key study, which a number of us have read and have discussed, in which a laboratory setting involved adding different amounts of various contaminants, to include dioxins, to a mixture of water. They would then see if, in fact, during the distillation process, if, in fact, it was removed or it would be co-distilled, it would stay with the water. Not only was it co-distilled, in fact, it was concentrated. That in itself provides a conceptual framework for how, in fact, on board the Australian ships, there could be Agent Orange and the contaminant of dioxin. As was mentioned by the authors in the article, they had regularly brought in estuarian water, that is water near the shore, so as to have less of a salt content to deal with. And for them, it made sense that that laboratory simulation would represent what occurred aboard the Australian vessels. As it would relate to the U.S. Navy, I understand from our DoD partners that as a practice by their standard operating procedures, they would have drawn in water for their distillation from 12 miles out. And so it makes it a little bit harder for this conceptual framework to apply to the U.S. Navy. But as I mentioned at the beginning,
In VA processing, if you knew for a fact that there were going to be COLA adjustments every year, would that allow us to get more benefits in the hands of
Thank you. And Mr. Berkman, you are recognized for 5 minutes.
Thank you, Mr. Chairman. Listening to the questions and the responses, we all, I think, would agree that life is complex, and as we try to combine science with what we know to be historical facts or times and place, it's a challenge. So I thank everyone for their engagement in combining all the different factors to come up with a good solution. Dr. Erickson, is the VA working with DoD to conduct a comprehensive review to determine exactly which ships operated in inland waterways of Vietnam?
Congressman, General, very much appreciate this question. Ms. Murphy could answer this as well. We have a ships list, which in fact has been collected over, I believe, several decades now. Now the ships list has over 300 ships listed. This has been an ongoing partnership with the Department of Defense, with the Department of the Navy to look at their records for where their ships transited, when did they come into port, when did they anchor, where were they, and the goal there being to actually lower the threshold for veterans. If in fact Navy veterans would be able to demonstrate that they were on a given ship that came into shore, that in itself would bolster their claims. And please forgive me if I'm stepping on your VBA side here.
Not at all. I would say that everybody is passionate about this, and this is the business we should be in, is hearing from advocates, doing research, talking to the experts, talking to our DoD partners, talking to our congressional partners, and really getting as much information and evidence on this topic and other similar topics that are of interest and passionate to veterans, because we want to find ways to pay benefits. But historically, we have to say no to some folks when there's not a rational basis or the evidence isn't there. So we continue to look. We want it to continue to be an issue for discussion so that we can get as much information and evidence on this as possible.
Okay, but in placing ships at a certain place at a certain time, is there a chart that shows which ships were in those inland waterways?
Yes, we maintain a ship's list.
So you have an exact list, so then we know exactly,
Yes.
given our rosters, who was aboard those ships at what time. So as the veterans come in and have a certain set of conditions, you can immediately go out to a list and say you were aboard the USS Okinawa LPH-3 during the so therefore, if all of a sudden we have, a certain number of people at a certain point in time who have a certain set of symptoms or conditions, it should make, it's not an exhaustive list, it's a finite list, right?
So, Congressman, yes, we have a ships list. There are several hundred ships, different categories of ships. We have gathered evidence and research in supporting putting those ships on the list. and we review it quarterly. We get information from DOD, and recently, I think we added 10 or 15 ships to that list. So, and by certain date ranges is applicable, and if a veteran comes in and we can, connect the dots and say, this ship is on the list, we can place that veteran on that ship during that time frame that is applicable, then we extend that presumption to them, yes.
Okay, and I'm glad you used the term connect the dots, because that is a lot of what we do in so many different ways here, is to connect the dots. And if we do it with data, which it seems like we have, then we're going to get the best results. Mr. Chairman, I yield back.
Thank you.
Let me put it on microphone. Mr. Saban, you are recognized for 5 minutes.
Thank you very much, Mr. Chairman and Ranking Member Esty, for holding today's hearing, and good morning, everyone. I just have a few questions, and maybe this one would go to Ms. Watts first, if you don't mind. Ms. Watts, under HR 1390, regarding the transportation of certain deceased veterans, and I really don't know the answer, which is why. Would 1390 include the territories under definition of states? Because it says state or tribal cemeteries. In my jurisdiction, we have one VA cemetery, but it's belongs to the Commonwealth, the territory I'm from.
Thank you, Congressman. I believe that there are territories that do have state, what we consider state veteran cemeteries.
So under state
They fall under,
territories
they
are
fall in the
included,
definition
like
of the state.
the Northern Marianas would be included under HR.
Potentially, yes.
1390.
And we would, there are certain state veterans, state and tribal cemeteries that we provide grants. VA provides grants to allow them to maintain those cemeteries. Now, that doesn't mean, I'm sorry?
Not for the Northern Marianas. Yeah, you don't even provide.
Not every state or territory has such a granted cemetery, that's correct.
Right, okay. So would it be asking too much to maybe sit down with us and consider including the territories? Or in particular, if all the territories except the Northern Marianas are included, would it be?
Yeah, we would be more than
Will
happy to
work.
have any discussion that you'd like to have.
Well, thank you. I appreciate that. Ms. Murphy or Dr. Erickson, would you please, would HR 1564, the VA Beneficiary Travel Act, would the transportation costs be authorized if the veteran were required to travel by sea or by air? I mean, you cannot drive around and, for example, for disability exams, if a patient from, I come from a place where there's 14 islands, 3 are inhabited primarily, but so there's always a requirement for 2 of those islands at least to travel either by sea or by air to come see a doctor.
So Congressman, as far as the beneficiary travel, we have been working with contract vendors to establish locations around the country and around the world for examinations. Where the contract vendors are located, we are paying for beneficiary travel to go to those contract vendors. But if that is not a location that is accessible to a veteran, or it's not someplace that we would send them, then we would be relying on VHA to provide that examination. And then we'd have to turn to VHA to look to its beneficiary travel rules for that. I will say also that we do have our disability benefit questionnaires that we do accept from private providers. So if someone were to take a DBQ to their private local provider and it were to be filled out by a licensed clinician, we would certainly accept that as well.
All right. I'm actually building together stories, so to say, cases, different situations that I would like to work with Veterans Administration to get some answers if possible, but thank you for
We
that
would be happy
answer.
to work with you and talk with you
I
more about
appreciate
that.
that. Thank you. I have just one more question again, Ms. Murphy or Dr. Erickson. In a jurisdiction, and this is on HR 1725, in a jurisdiction where there are no VA health centers or VA clinics, wouldn't it be reasonable to allow medical or private practitioners' opinions to be sufficient for rating purposes, and not require the veteran to travel by sea or by air for an examination to see a VA doctor? Otherwise, you have to send them to Honolulu. And of course, sometimes they have to, there are many instances that I'm aware of where they put up their own money to go to a Matsunaga Center, for example, or try and see a doctor in Guam if they can. I don't have time, but
Congressman, that's absolutely an opportunity they have. We accept private medical evidence, and if it is sufficiently comprehensive and answers all the questions that we need for rating purposes, we use that.
I understand. Okay. Thank you. Thank you, Mr. Chairman. I yield back.
Thank you. There's no one else on the dais seeking to ask questions. We want to thank this panel for being here today, Ms. Murphy and everybody involved. Thank you so much. And we want to invite up the third panel. I want to thank you as a panel for being with us. Mr. Zachary Hearn is with us, the Deputy Director for Chair Claims of Veterans Affairs and Rehabilitation Division of the American Legion. Mr. Rick Weidman, the Executive Director of Policy and Government Affairs for the Vietnam Veterans of America. Mr. Patrick Murray, the Associate Director of National Legislative Services for Veterans of Foreign Wars, and Mr. Leroy Acosta, the Assistant National Legislative Director of the Disabled American Veterans, and also Mr. John B. Wells, the Executive Director of Military Veterans Advocacy Incorporated. First off, I want to thank you all for being here and for working for the work you and your organizations do every day to improve the lives of our veterans. We want to thank you for that. Mr. Hearn, we will begin with you, and you are recognized for 5 minutes.
Good morning. The simple fact is, serving in our nation's armed forces is inherently dangerous. Medical conditions may manifest due to service, and we as a society have an obligation to compensate for medical conditions related to service. Many of these veterans depend upon these benefits, and for this reason, it is imperative that we ensure these deserving veterans and their family members receive the highest level of consideration. Good morning, Chairman Bost, Ranking Member Esty, and members of the subcommittee. On behalf of National Commander Charles E. Schmidt and the nation's largest veterans service organization, we welcome the opportunity to testify regarding pending legislation. The American Legion supports the passage of H.R. 105, designed to protect veterans from the unscrupulous act of fiduciaries. Veterans requiring fiduciaries are some of the most vulnerable veterans. Half of these veterans are over 80 years old. All of them are unable to manage their financial affairs. Veterans who have been impacted by poor acting fiduciaries do not have the ability to recoup their lost funds from VA unless the fiduciary represents 10 or greater beneficiaries. This bill would now permit VA to provide the lost funds to the veteran regardless of the amount of beneficiaries represented by a fiduciary. H.R. 299 corrects a wrong that has plagued the Blue Water Navy veteran community and affords the veterans the benefit of doubt to herbicide exposure. Over 800,000 Blue Water Navy personnel served in Vietnam's territorial waters between 1962 and 1975. VA has repeatedly stated there is no conclusive evidence that supports presumptive herbicide exposure. The Institute of Medicine's Committee on Veterans and Agent Orange stated that there were no environmental studies conducted during the Vietnam War, and due to that fact, it cannot determine the occurrence of herbicide exposure. In short, VA cannot prove Blue Water Navy veterans were exposed to Agent Orange, and it appears they never will. Blue Water Navy veterans for years have pointed to the 2002 Australian study that found the distilling of seawater not only failed to eliminate the toxic chemicals, but it enhanced its impact. For a Blue Water Navy veteran to gain service connection due to herbicide exposure, proof has to be provided that exposure occurred. VA is essentially directing veterans to provide proof of exposure to a chemical that few knew of its impact half a century after the incident. As you can imagine, this is a near impossible task. The American Legion has long believed that these veterans of the Blue Water Navy deserve to be treated as presumptively exposed and supports this bill. H.R. 1328 provides an automatic annual cost of living adjustment for veterans' disability benefits. While this bill would prove efficient in the administration of COLA, it also could come at a significant cost to the veteran, as it uses the chain CPI as its foundation. The current CPI COLA formula suggests a 30-year-old veteran with no children and 100% disabled would likely lose about $100,000 in disability compensation by the time the veteran reaches 75 years of age. This is the equivalent of years of benefits lost due to this bill. The American Legion opposes this bill and any legislative efforts to automatically index COLA to the COLA authorized for Social Security recipients, non-service-connected disability recipients, and death benefits. H.R. 1329 increases the rate of compensation as of December 1, 2017 for veterans with service-connected disabilities and surviving spouse benefits. When inflation impacts the cost of living, it is natural to adjust benefits according to the increases. The American Legion supports this bill. H.R. 1390 authorizes VA to pay costs associated with transporting deceased veterans to state or tribal-owned veteran cemeteries. VA currently pays transportation costs only for national cemeteries. This bill will expand options for veterans' families, and the American Legion supports this bill. H.R. 1564 specifies a funding source for travel related to examinations by medical professionals not employed by VA for compensation and pension examinations. This bill properly designates where VA draws funds for veterans to receive payments for travel to C&P exams and does not impose additional funding requirements. We support this bill. H.R. 1725 improves the treatment of medical evidence provided by non-VA medical professionals supporting disability compensation claims. It is unfortunate that a bill has to be passed to force VA to do what it already has the authority to do. The American Legion regularly reviews VA adjudications, and frequently, VA schedules exams despite having the necessary evidence available to decide a claim. This second exam comes at a cost to VA and delays an adjudication. Additionally, this process is often frustrated by raters' near whole dependence upon its evaluation builder tool that doesn't allow for the weighing of evidence. This bill allows for a streamlining of adjudications through rating based upon acceptable clinical evidence, and the American Legion supports the bill. Again, on behalf of National Commander Charles E. Schmidt and the 2.2 million members of the American Legion, we appreciate the opportunity to speak this morning on today's bills. I'll be happy to respond to any questions provided by the committee. Thank you.
Thank you, Mr. Hearn. Mr. Weidman, you're recognized for 5 minutes.
Thank you, Chairman Bost. I look forward to getting to know you, particularly in this new role. And Ranking Member Esty, I hear such great things about you from Linda Schwartz and our folks in Connecticut that they think you can walk the entire length of the reflecting pool in front of the Lincoln Memorial without getting wet. So I look forward to getting to know you. I will comment just on 2 bills today, and we favor most of, actually all of the bills that are on the docket for various reasons. First, I'll touch on the Protect Veterans from Financial Fraud Act. The fiduciaries at VA have been a scandal for as long as I can remember. And VA already has the statutory authority to investigate and to bring charges against those that are stealing from veterans who are not able to defend themselves, but they have not done it. And while we favor this particular act, what's really necessary is oversight hearings that demand that they follow the statute and regulations pursuant to the statute to safeguard those individual most vulnerable of our veterans. So I just want to say that as a start, and that you're going to accomplish, I believe, much more in passing the legislation. We have no problem with that. But I encourage you, Mr. Chairman and Madam Ranking Member, that you pursue some oversight hearings on this. The Blue Water Navy Vietnam Veterans Act. The Institute of Medicine, in every review they've done since, without evidence, the VA said no more Blue Water Navy. And to show you how absurd their definition is, they draw an imaginary line across Da Nang Harbor. And if, in fact, you're here in the water, you're not exposed. And if you're here in the water, 2 feet away, you are exposed. It's preposterous. It's not scientific evidence. It is simply wanting to say no. Vietnam veterans generally believe that the policy of the VA when it comes to any kind of toxic exposures, but particularly Agent Orange, is delay, deny, and wait for us to die. And frankly, there's very little to controvert that. Almost everything in the environmental hazards and public health section of VA may be really nice people who are good to their family, but by God, they are not proper arbiters of science. They just simply aren't. The Institute of Medicine study that was done, they were in the charge was to find out whether or not it was plausible, and they did find that it was plausible. They did replicate the experiment of the concentration of the dioxin and found out it was correct. That's the first time that IOM, as part of one of their reviews that I know of, where they've actually gone and done original scientific experiment in order to see for themselves what's the deal. When the report came out, they said, yes, it is, in fact, plausible, and in fact, we believe it happened. As you may know, and everybody should understand, that Agent Orange, Agent Pink, and the other defoliants were mixed with a mixture of kerosene and JP4. And what does that do when it hits water? It floats near the surface. It floats near the surface way the heck out to sea, and where it would then be picked up. Although Agent Orange is not water-soluble, in fact, it is water-suspensible, and that's what happened because it was wrapped in the envelope of those petroleum products that did, in fact, keep it near the surface. Coming back to the IOM study, they were charged with finding out whether there was a mechanism whereby people could be exposed. And they showed that that was the case. Under pressure from VA, then turned around and said, well, we can't really make any recommendation on this because we have no idea how much folks were exposed. And we said, so what? You have no idea how much I was exposed in I Corps, northern part of the Republic of Vietnam, otherwise known as South Vietnam, versus my colleague who served in 4 Corps with the 9th Infantry Division down in the southern part of Vietnam. And VA decided with the assistance, shall we say, of the Congress in 1991 to say this is absurd, we're never going to figure out who was exposed and not. Let's look at the effects of this thing. And the VA, since the Blue Water Navy, they have tens of thousands of Navy vets who use VA services. It's very easy to find out who has a Southeast or a Vietnam service medal and who does not. And if those who do not, who served on a similar vessel in the Atlantic or the Mediterranean, compare their health to those who have a Vietnam service ribbon. This is not a hard thing to do. It's not an expensive thing to do, but they haven't even requested that it be done. And we're with the National Academy of Medicine in recommending that they be restored. We know, as valuable and as important and as righteous as this bill is, because of offsets, it probably won't be able to bring it to the floor. But all of you on this committee, on a bipartisan way, should pressure the Secretary to say, this is absurd, include these veterans back in. Congress in the 91 Act intended for them to be in. So I'm over time. I thank you for your indulgence of the extra 1 minute and 4 seconds, sir.
Thank you, Mr. Wyden. And with that, we'll recognize Mr. Murray.
Chairman Boss, Ranking Member Esty, and the members of the subcommittee, on behalf of the men and women of the Veterans of Foreign Wars of the United States and our auxiliary, thank you for the opportunity to provide our remarks on legislation pending before the committee. The VFW supports Blue Water Navy Vietnam Veterans Act, which would require the Department of Veteran Affairs to include territorial seas as part of the Republic of Vietnam, extending presumptive service connection and health care for Agent Orange-related illness to Blue Water Navy veterans. Currently, VA relies on what the Court of Appeals for Veterans Claims has called arbitrary and capricious interpretation of inland waterways, which unjustly denies veterans who served aboard ships in the coastal waters of Vietnam the benefits they deserve. The VFW believes the Blue Water Navy veterans were potentially exposed to significant levels of toxins and should be granted the same presumption of service connection as their counterparts who served in the inland waterways of Vietnam. The VFW strongly supports the American Heroes COLA Act and the Veterans Compensation Cost of Living Adjustment Act, which will increase VA compensation for veterans and survivors and adjust other benefits by providing a cost of living adjustment. The VFW is pleased to support any bill increasing COLA for our veterans. However, we would prefer to make COLA increases permanent and automatic. Disabled veterans, along with their surviving spouses and children, depend on their disability compensation plus dependency and indemnity compensation to bridge the gap of lost earnings caused by the veterans' disabilities. Each year, veterans wait anxiously to find out if they will receive a cost of living adjustment. There is no automatic trigger that increases these forms of compensation for veterans and their dependents. Annually, veterans wait for a separate act of Congress to provide the same adjustments that is automatically granted to Social Security beneficiaries. The VFW supports the Protect Veterans from Financial Fraud Act, which provides the ability of veterans assigned fiduciaries to be compensated for having their money mishandled or misused. We see this bill as a common-sense method to protect some of our most vulnerable veterans. If a veteran is assigned a fiduciary for whatever reason, they need help and financial protection, and individuals who mistreat or prey upon their clients should be held accountable, and compensation must be made to those affected. To go further, the VFW supports adding legislation that installs criminal penalties for those found to be intentionally preying upon veterans for any other financial gain. We would like to see this expanded to any attorneys or claims specialists that charge a fee to process initial claims. Abusing the health and financial welfare of veterans in need should be punishable by law. The VFW strongly supports the Quicker Veterans Benefits Delivery Act in order to help diminish the workload within VA. The VFW recognizes that the VA should still be the primary driver in taking care of patients' examinations, but we also realize that using third-party medical evidence that the VA to help is necessary to reduce the workload. Until the backlogged files begin to diminish within the VA, they should continue to utilize private physicians' evidence to help shrink the number of claims and appeals. Veterans should not have to see another VA doctor in order to review and confirm private outside doctors' findings. This only adds to more confusion and clogs up the system. The VA needs to allow acceptable clinical evidence from competent, credible physicians and not force veterans to seek a second opinion from a VA physician. While the VFW supports this bill, we do not feel it covers one of the most important medical issues facing veterans today, which is mental health. If the VA allows third-party physicians to examine veterans for almost all physical conditions, they should also utilize the appropriate medical professionals to examine mental health. Mental health examinations are increasing every day, and the VA insisting on patients seeing only VA doctors for initial examinations is increasing the burden on their own system. Initial mental health examinations should be added to the type of evidence accepted by VA examiners. Mr. Chairman, this concludes my testimony, and I'm prepared to take any questions you may have.
Thank you, Mr. Murray. With that, we'll go to Mr. Acosta.
Thank you, Chairman Boss, Ranking Member Esty, and members of the subcommittee. Thank you for inviting DAV to testify at this legislative hearing of the Subcommittee on Disability Assistance and Memorial Affairs. As you know, DAV, a nonprofit veteran service organization comprised of 1.3 million wartime service-disabled veterans, is dedicated to a single purpose: empowering veterans to lead high-quality lives with respect and dignity. I'm pleased to be here to present DAV's views on the bills under consideration by the subcommittee. H.R. 105, Protect Veterans from Financial Fraud Act of 2017, would require the VA to repay veterans those benefits that were misused by fiduciaries and establishes an appeals process for determinations of veterans' mental capacity. DAV does not have a resolution specific to this issue. However, we would not oppose passage of this legislation. H.R. 299, the Blue Water Navy Vietnam Veterans Act of 2017, would expand the definition of the Republic of Vietnam to include its territorial seas for the purposes of the presumption of service connection for diseases associated with herbicide exposure. Benefits under this bill would be retroactive to September 25, 1985. DAV supports H.R. 299 based on DAV Resolution Number 18, which calls for the addition of the territorial waters of Vietnam to be included in the presumption of exposure to service connection for herbicide-related disabilities. Mr. Chairman, DAV Resolution Number 13 calls on Congress to support legislation to provide a realistic increase in disability compensation. DAV supports the provision in H.R. 1328 and H.R. 1329, which would increase veterans' disability compensation, survivor benefits, and clothing allowances by the same percentage as Social Security benefit increases. However, DAV is concerned about the automatic adjustment provision in H.R. 1328. This may adversely affect congressional oversight meant to protect against the erosion of these critical benefits, particularly in years where there are no COLA increases, such as in 2015, or minimal increases, such as in 2017. H.R. 1390 would permit the VA to cover the costs associated with the transportation of deceased veterans not only to national cemeteries, but also to other recognized veteran cemeteries. DAV does not have a resolution specific to H.R. 1390. However, we would not oppose its passage. This legislation would benefit veteran survivors by helping to offset the cost of transporting the veteran to their final resting place. H.R. 1564, VA Beneficiary Travel Act of 2017, would amend Section 504 of the Veterans Benefits Improvement Act of 1996 to specify the funding source for travel related to examinations by physicians not employed by the VA regarding medical disabilities of applicants for VA benefits. DAV does not have a resolution. However, we would not oppose passage of this legislation. The Quicker Veterans Benefits Delivery Act of 2017 would amend Title 38 U.S.C. to improve the treatment of medical evidence provided by non-VA medical professionals in support of veterans' claims for disability compensation. Mr. Chairman, DAV is pleased to provide our support of this bill, consistent with DAV Resolution Number 230, which seeks the enactment of legislation that would require VA to consider private medical evidence supplied by licensed private health care providers in private practices. This bill would give due deference to private medical evidence that is competent, credible, probative, and otherwise adequate for rating purposes. Mr. Chairman, this concludes my testimony, and I'd be pleased to address any questions related to the bills discussed today.
Thank you, Mr. Acosta. Then we want to move on to Mr. Wells. You're recognized for 5 minutes.
Thank you, Mr. Chairman. Ranking Member Esty, my name is Commander John Wells, USN, retired, and I appreciate the opportunity to testify. We're going to talk mostly about the Blue Water Navy Vietnam Veterans Act. I talk a little fast, especially since I'm going to try to go over some of the questions and red herrings given by the VA in their testimony to provide some real answers. First of all, I know that they're interested in the definition of territorial seas. That's set by treaty. 1958 Convention on Territorial Seas in the contiguous zone, which has been ratified by the United States Senate, and ratified treaties become part of domestic law. We also recognized the territorial seas and Vietnamese sovereignty over them in the 1954 Geneva Accords and the 1973 Paris Peace Treaties, and court decisions of the Fifth Circuit and the Supreme Court of the United States specify that we will follow the definition of territorial seas. To make it easy, in an attachment 1 to my testimony, we've shown you where the territorial seas is. It's the dashed line in there. So we would ask that that be made part of the legislative history of this so the VA won't define territorial seas as some lake in the middle of Hanoi. The 1985 date was picked because of the effect of NEMR. You won't be adjudicating cases back to 1985, but if there are new diseases which come about, we would get the same benefit of NEMR as our Army and Brown Water brothers would. In effect, these rights were stripped away from us by the VA in 2002, so you won't be looking at any more claims until 2002 would be the earliest date, and many of those claims have expired. Unfortunately, many of the veterans have expired as well. As far as the time to adjudicate these claims and so on and so forth, Mr. Chairman, Ranking Member Esty, members of the subcommittee, we are the backlog. We have kept those going, okay? And if you pass this bill and give the presumption, there's going to be a whole lot of cases in the appellate backlog and in the individual claims backlog that can be immediately adjudicated and corrected. So, and that's the truth of the matter. The VA talked about cost. They threw out a $900 and some million figure, I think, for the first year. No, that's not the case. And attachment 5 to our testimony gives the CBO estimate of $1.104 billion. I've seen them give up cost of $20 billion. I've seen them given cost of $4.4 billion is what they told the Senate in the last Congress. Let's look at what the CBO says, $1.104 billion. I've met with the CBO. If anything, and they will agree with this, it's probably a little high at this time because of the ships added to the ships list. And by the way, the DOD and the VA aren't working together on that. That's input coming from organizations such as the Blue Water Navy Vietnam Veterans Association and some other organizations that do it. There's one guy in Cleveland, Jim Samsel, who does it part-time. So, General, in answer to your question, no, they aren't doing what they should do, is going out and saying, hey, Navy, where were the positions of these ships vis-a-vis Vietnam? We did have a bill that passed the House twice that would have done that 2 Congresses ago. We haven't brought it back up again, but we sure like to see it brought up again because that would help us identify some more ships that have gone in the river. Ms. Murray talked, I'm sorry I'm talking fast, Ms. Murray talked about, talked about rationality, and there has to be a rational basis. Well, we agree with that. We certainly do. But what she didn't mention is the Court of Appeals for Veterans Claims in a case called Gray versus McDonald came out and said that the exclusion of the bays and the harbors are just simply irrational and, as somebody mentioned, arbitrary and capricious. Now, they say there's no evidence that the Agent Orange got there. Mr. Chairman, I've shown you and probably half the people sitting up there Exhibit 2 to our testimony, which shows where the bottom sediment samples were taken in Nha Trang Harbor, and Exhibit 3, which shows the toxicity levels 20 years after the war. So they can't say it's not there. They don't mention the water barges, which were taking water from Da Nang Harbor's Monkey Mountain, this area up here that looks like it's lowland. It's actually jungle. It was sprayed throughout the war. There was a reservoir there. That water was taken on, and your staff has all this information. And they took it around to the ships. And by the way, let's talk about another fallacy. They say that the Australian study was invalid because U.S. Navy ships did not make potable water within 12 miles of shore. That's not true. There was a manual of the medicine department publication which suggested it, but I know for a fact, and I was the chief engineer on a number of these ships, water was my business, that they did make water, even potable water, in some of the harbors, and certainly close to shore. They had to keep the water tanks going. More importantly, they always made feed water for the boilers, and guess what? It's the same distillation system down to the final discharge valve, and we've told the VA this before. They know it, okay? So that's just, even if they were only making water for the boilers, it would still have been contaminated water, okay? And I'm sorry, I'm starting to pull a Rick Weidman here and go over time, but just a couple other quickies. As far as studies go, the Australian Cancer Incidence Studies shows a much higher rate of cancer incidence among those that were in the Navy as against those who went to shore. And the CDC's non-Hodgkin's lymphoma study says the same thing. And by the way, the Institute of Medicine, the VA will always misquote this. In the sentence that they say is they can't say definitely that there was no Agent Orange exposure. The very next sentence says, there's no more or less evidence to show exposure of blue water Navy than there was the brown water or the people ashore. This was never about science. It was about a bad general counsel's opinion, and when we called them on it, they circled the wagons, and they still do. I do have a meeting coming up with Secretary Shulkin on April 21st, and we have oral argument on a court suit coming up on May 5th, so we are pursuing all matters. I understand I'm over time, shows I can talk longer than Rick, but the problem is there's so much to cover. But you know, Mr. Chairman, we had plenty of money to send those guys to war. We should be able to pay for them when they get back. I put some ideas in my written testimony. Senate has shot us down on a couple, but frankly, we don't care how you pay for it. But you need to pay for it. These guys are dying, and their families are being left destitute because of medical bills. We owe them better than that. Thank you, Mr. Chairman.
Thank you, Mr. Wells. I'm going to go to questioning now, and I will yield myself 5 minutes. First question is for the panel as a whole, okay? Before we get to a lot bigger subject, but this is just real quick. This question is for all witnesses, I said. Veterans and their families and their benefits assume that they receive a COLA next year. Hold on. The question is, for all the witnesses, how would veterans and their families benefit assuming they received a COLA next year? Mr. Herman, we'll start with you.
They would certainly benefit by adjusting for the cost of inflation. I guess I'm kind of confused as to where you're going with the question. I mean, if the cost of living goes up, it's only natural that Congress responds accordingly and provides that compensation increase.
Okay, maybe I should expand on, I think in your testimony, the concern you had was that you feel that Congress needs to make every year.
Correct. As far as the concern that we have is dealing with the change CPI, and if you project that going out over decades, the amount of money that's lost, and the one sample that we used was it would be roughly about $100,000 over a 30 or 40-year span. I pulled up the average income for one of your residents in your district.
Okay.
That's roughly $30,000, I think, somewhere in that area. That'd be three years worth of salary for your average constituent. So that's a sizable amount of income. Obviously, it would vary between the ranking member and yours, but
of course,
but nonetheless, it would still be a costly endeavor over decades.
Let me ask this, and you know that I'm going to do everything I can for the veterans. This
Yes.
is trying to do the thing that's right. My concern that I have when you say, okay, don't do this, is then you're just depending on Congress to make a decision rather than setting something in place that actually guarantees and gives some sense of that there is going to be that COLA. And it's the same thing with Social Security, as you know, I mean, so I was a little concerned in your testimony when you said that you.
Well, I mean, and the American Legion's position is pretty simple: is that the veterans didn't provide a diluted service to their country, and that this would provide a diluted benefit if you're talking about that over decades. And I understand where you're going with this, but I also know that $100,000 is a sizable amount of income, and I agree. We're relying upon Congress, and sometimes Congress doesn't get along very well. But over time, that we also don't want our veterans to be harmed just in the need of efficiency. If 30 or 40 years we look back at this testimony today and said we harmed our veterans, I don't think any of us in this room would feel good.
And then I want to go down the panel with the same question, but the only thing I would say is one thing that we're known for, and that's the big fear, is that if we do nothing, nothing will be done.
Correct.
VVA favors the automatic. We do, however, think that really should take a hard look at the basic level, particularly at the 70, 80, 90% level, and as well as 100%. It's if in fact somebody's 100% in a metropolitan area like Washington, what you're doing is guaranteeing people will be below the poverty line for the rest of their life, and that's just not right.
Right.
The VFW simply supports the automatic increase in COLA. We think it is easier on the recipients, it's easier on Congress, so we don't need to be sitting here every year doing this.
Many service-connected disabled veterans rely on their disability compensation for their livelihood. to take care of bills apart from their civilian counterparts. It's important that we get a realistic increase in those benefits so they can realize life in the country that they served.
Mr. Wells?
Automatic is good. That way we don't have to fool with it, you don't have to fool with it, and it's gives you all more time to kind of concentrate on some other things, so we support it.
Yeah. Okay, I'm running short on time, and I know now it's going to run over, and then I don't want to be thrown off, like the chairman said. But let me tell you that this is an important question to ask, and all of us, I think, are fighting for the same goal, but we've got to ask it. Last Congress, CBO estimated that the legislation for the Blue Water Navy would be a $1.1 billion offset in mandatory funds. To avoid adding to the deficit, and then we fall under the existing rules that we have here. Though many of us, probably all of us on this panel, would want to make sure that would happen. The question that I have is, and I know that Mr. Wells, you said you didn't care where it comes from. We have to care where it comes from. And even though I love my veterans more than anybody else I fight for, and will continue to do that, we have to have that answer. So what any suggestions do you, any member of the panel, have? Mr. Weidman.
We went to war on a credit card. The war in Iraq and Afghanistan is the first time in American history where we have had a tax cut, in fact, two, during wartime. So we didn't make the commitment to pay for the darn wars. Instead, we took it out of OCO, which is nothing but an unsecured credit account. If you can go to war without having to find an offset, then by God, you ought to be able to pay for those torn up in that war without an offset.
Okay, maybe a follow-up question to the rest of you as well, and I know I'm out of time, but I'm gonna be like the two on the panel. The question is there something we can work on in the bill that would actually be something that we could argue that would bring cost, the cost in paperwork down? You understand what I'm saying? So that the estimated cost, if we don't agree with the estimated cost, maybe we think that, okay, well, the assumptions are a little bit high, or something like that, so that we can come back and deal with an argument on what the costs are. And like I said, I want to, if I do it, I want to be paying for them.
Mr. Chairman, there's several things. First off, you know, I do have the meeting with Secretary Shulkin. It is possible that he would just restore the benefits, in which case it could become under appropriations and the cost of the bill will go to zero. Secondly, we do have our pending oral argument in the Court of Appeals to the Federal Circuit. If we win that case, then the bays and the harbors would be covered. We would estimate that about 90% of the ships would be covered, and our estimate of the 10-year cost would then fall down to about between 100 and 150 million over 10 years. But assuming we cover everybody that went in the harbors. But here's the kicker, and yes, you have to understand, it's hard for me to go back and talk to my veterans and say, and explain the PAYGO Act to them, because they're the ones that are dying. I understand PAYGO, okay? I think it's done a great job in a lot of ways, but now this is something that we really have to look at, because there's not a lot of mandatory spending left in the VA budget. There was some in the home loan. We suggested that, and it got sucked up into the Choice Act. There are going to be some automatic offsets, which I'm not sure CBO has applied. First of all, people that are now eligible for for a veteran's pension, okay, if they served in time of war and make, I think it's less than about $14,000 a year, they get a veteran's pension. That would be offset by the benefits, and so there'd be a dollar-for-dollar recovery there. Secondly, anybody who has retired and is getting a retirement pension, if their disability is 40% or less, there'd be the VA waiver, which would be a dollar-for-dollar offset. We don't know what those numbers are because VA won't give us the figures. But there's other things that we need to look at. A number of people went ashore. Now, they have problems proving that, and VA will want, 20,000 affidavits and a video to show they were ashore. But probably about any one time, about 10% of the fleet went ashore. They had to go see the doctor, the dentist, the lawyer, the chaplain, call home. They got transferred on and off. They made a mail run into the into the harbor, you got boat crews, you got helicopter crews, go pick up some supplies, whatever. There's a number of those people, and there's no way to determine those numbers.
Right.
But our estimate is about, based on facts, is about 10%, okay, that those are going to be offset. Now, the other thing is, if some of these folks are picked up under the VA system, there was a CBO report that came out in December of 2015. I realize this is, I may have the year wrong, it may have been 2014, but I realize this is discretionary spending, not mandatory, but says it's about 21% cheaper to send somebody through the VA system than it is to do Medicare reimbursement, which makes some sense. And if you've got TRICARE for life as your secondary, it's probably even more than 21%. Those are old numbers. It was before choice, but it's still a factor. Okay. All that being said,
Mr. Wells.
can I make the bill pay for itself? No.
Let me go ahead and switch over to Ms. Estes, because I've almost went 5 minutes over on my time, and said I wouldn't do that. But this, I think it is vitally important. So, Ms. Estes, your turn.
Yeah.
Thank you, Mr. Chairman. We'll pick up with this. And Mr. Weidman, I definitely cannot walk on water, I guarantee you. But Linda Schwartz is awesome, and we are happy to have her back in Connecticut. And we're going to be using her as a resource for this committee. And her passion and commitment around Agent Orange is in part what inspires me and helps me work every day on this. So we're going to pick back up, Mr. Wells, with figuring out how we're going to pay for this. Because one of the things I think is important to note, and all of you have referenced this, is the cost to the system of trying to determine who's in and who's out, and that's part of the reason for presumptive. And I'm not sure that the CBO scoring is really looking at that. And again, you are all right. Everyone is happy to be there when we send our troops to war. We need a solemn commitment to take care of them when they come home. That's part of the reason we need to be all over them right now, I think, on burn pits, to not repeat with the current veterans what has happened with this delay, deny for Vietnam vets. So if you pick back up with
thank you, Ranking Member Esty. One of the things is the Blue Water Navy is the tip of the spear. There's plenty of other Agent Orange exposures, which we can go through at length. There's burn pits, there's Fort McClellan, there's all kinds of toxic exposures. In our written testimony, we recommended a brand new funding source. We think to cover all toxic exposure research, kind of a follow-on to what was passed last year, and toxic exposure benefits for burn pits, Fort McClellan, and so on and so forth. It's probably going to be north of $20 billion a year. We recommended a $10 fee for everybody that puts in a tax return, okay? Now, you could make it voluntary, and you're probably not going to get that much, but it would still be some. If you make it mandatory, we're talking about everybody who files a tax return, and there's 250 million filed every year, okay, in this country, to pay what we call the freedom fee, okay? And that will generate not only money to pay for the Blue Water Navy, but the other Agent Orange exposures, Guam, Panama, wherever, Fort McClellan, burn pits, and so on and so forth. The fact is, there's just not enough mandatory spending left there to go around. I think we need a new funding source. That seemed to be a fair way to do it.
Thank you. Anyone else who didn't get a chance to do that? All right. Mr. Weidman, you did not speak quite as quickly as Commander Wells. Anything else you'd like to add to your testimony?
The VA never should have taken the Blue Water Navy sailors out of the group that was eligible for presumption in the first place. All of the evidence since is that they belong, and it should be restored, and that poor decision should be reversed. What wasn't said by our friends from VA was that the first thing they said was our desalinization units didn't work the same way. We used a different theory. And then it was pointed out that not only did we do it the same way, but the desalinization units on the Australian ships and the American ships came from W.D. Burroughs and Sons and were installed by the American company on the Australian and the American ships. So now they've moved to, you can't tell how much anybody got. Well, we finally, in that, when I mentioned the IOM report, and the chair trying to convince Association of the United States Navy and the Fleet Reserve and the Legion representative and me that somehow this meant that nobody should be granted presumption. So we said, so why? Because you can't measure how much dioxin? She said, yes. And so we asked the question, what dose of dioxin is safe? And she, with all due respect to a lady and who's no doubt a good scientist, her eyes got as big as, not saucers, big as great big dinner plates. And she said, well, there is no safe dose of dioxin. Admitting that once you've got biological plausibility, and you could replicate this experiment about how far out at sea, it then reveals that the whole process inside VA Veterans Benefits and inside the environmental hazards and public health section, frankly, is not science, it's sophistry. We should have public servants there who we can rely on to be neutral arbiters of science, and we would suggest that they're not.
Thank you very much, and you are correct. It is 0 level of safe exposure to dioxin. We all know that. That's the basis of EPA regulations all across America on this issue, and it is doubly true for those that were sent in harm's way to defend freedom. And if you would, please make sure that we get entered into the record the full relevant reports which you have referenced from the National Academy of Sciences and Institute of Medicine, which I'd like to make sure that those full records are included with the relevant discussions about the comparative difference between the certainty that there exists and the certainty that there exists for blue water versus brown water and territorial. Thank you very much.
Thank you, and Mr. Bergman.
Thanks, Mr. Chairman. Thank all of you for your testimony this morning. It makes a difference. Mr. Hearn, please explain why you believe it is important to codify a veteran's right to appeal VA's decision to appoint a fiduciary.
The American, I mean, if VA assigns a fiduciary, there have been times where a physician will ask the veteran, do you manage your financial affairs at home? Or does your wife pay the bills? In my own house, my wife pays a good portion of the bills, and using their logic, I suppose I should have a fiduciary. Please don't, but that's the reason. I mean, people make mistakes. That's human. So I think that's some of the reason why. That's one of the bigger reasons why we should be appealing, why those issues should be appealed.
Okay, so you're trying to provide a little extra assistance for that veteran?
Well, I mean, if the veteran does not deserve, if the veteran feels that he or she does not deserve a fiduciary and has been misunderstood during an examination, I don't think you would want to have those rights taken away from you. Other times, there are issues dealing with Second Amendment issues that pop up, because if you've been assigned a fiduciary, sometimes they say we need to pull your weapons from you, and that's certainly something that the American Legion is against, just because the two don't necessarily correlate.
Okay, thank you. Mr. Hearn, based on your experience working with veterans' claims, does the VA routinely accept competent medical evidence from qualified private physicians when evaluating claims?
I wouldn't say routinely. The biggest problem that we have noticed has dealt with this evaluation tool builder. Imagine being a GS-11 or 12 out of some regional office making adjudications, and the evaluation builder says this, but it does not have any measure, any way to weigh evidence. It doesn't allow for lay testimony to be included. It doesn't include continuity of symptoms. This is a failure. This is a big failure on VA's part, and it's a failure that even the regional offices are noticing while we're doing these regional office reviews. And it really raises questions about the quality of adjudications when you've got a tool that the employees are feeling compelled to use, even though they recognize at times that it doesn't consider all of the evidence that's of record.
Okay. Any other members of the panel care to comment on that question?
The reason why they even if there is adequate clinical evidence in the file, that they request an exam is CYA, sir. Simple as that.
Okay. Anybody else? No. Thank you. Mr. Chairman, I yield back.
Thank you. Mr. Seblin?
Yeah, thank you very much, Mr. Chairman, and thank you, gentlemen, for joining us today. When I, in the beginning of this term in Congress, I asked if I could receive a waiver to be in this committee, because I noticed an increasing number of casework from from my district of veterans. And I'll be very truth be told, I didn't know there were so many veteran service organizations. I am aware of the presence of veterans of foreign wars out there, because there are times when we have a burial of a veteran and it's a member of the VFW who plays the tap. Sometimes the Army Reserves are giving orders to give the gun salute, but nowadays I think they need an order to do it. Even if they voluntarily want to do it, they can't without orders. But I'm just getting such an education. I didn't know about this dioxins. I knew about Agent Orange, but I didn't know about this color of rainbow. Basically, a lot of these different things. The Vietnam War, I was a young, but I don't know if you guys went to war. I don't know why we went to war. I became an American in 1986. We became a part of the United States in 1978, and so last November, Veterans Day, I took the liberty of presenting a tribute to Vietnam veterans. And I didn't know it meant so much, and so many of them came up to me and said, thank you. But this gentleman who I know came up to me in tears and said, thank you, because all I did was say, welcome home, from a very, I think, unpopular war is what it was called. But thank you for what you do. I don't know if we have DAVs or, but I will continue to work with this committee. This committee has been very helpful to me, and with, of course, the Veterans Administration. In the Northern Marianas, we have a doctor that when I got in, there was no medical service, so I think the contract was negotiated, but it was somebody filed it somewhere, and I think the file got lost somewhere, so they found it, and we got a physician on contract, and she can only take so many, so I think they got another one. But we're so far removed that we were forgotten. So we do have a VHA staff now. The individual suffering from PTSD get a counseling through a television screen. It's just incredibly unfair to someone who has put on a uniform and gone to Afghanistan and come back and can't see a doctor because they won't give him a counselor, psychologist or psychiatrist. They instead tell him that you have to come and sit down in front of this table and there's a TV screen there and someone at the other end will talk to you. We did a test of the resource provided through the VA's major contractors. We found out that some people on the list didn't know they were contractors. Some of the people on the list are no longer, they moved away. But we got a new list and we checked and some of them are now okay. The emergency crisis line works, but it gets referred to Hawaii and the time zone is, different. But I'm here because I do want to try as much as I can to help those veterans who have served their country. They put on a uniform. These people were whole when they left home. When they came back, many of them were broken. Some of their wounds we can't see. But thank you, everyone. I'm truly getting an education from all of you. And Mr. Chairman and Ranking, thank you for holding today's hearing. I appreciate it. I yield back.
Thank you, and I do want to go ahead and go around one more time if anybody that might want to, but I want to limit it to 3 minutes. I think we're into this enough. I know there's other hearings going on, but this is vitally important. And for those that didn't answer, I want to have the chance to respond. Understand, neither one of us were around when the rule for the offset was written, okay? But it is something that we have to do when we move forward with our colleagues. For any one that didn't have the opportunity to have an input for possible offsets, if you have suggestions right now, if you come up with them later, but I would open it to anyone that would want to respond for possible offsets. That's kind of the response I've been getting to. So let me say this, and that was the main question. One thing I do want to ask, Mr. Wells, you talked about the $10 fee, okay?
Yes, sir.
$10 fee is basically a tax increase because basically if everybody fills out a form, we'll then pay a $10 fee. So it is a tax increase, but I'm not
Certainly.
arguing against it. I'm just wanting input. Have you raised any of these ideas with other committees that are present here in Congress, Ways and Means staff, or any other congressional staff, because as they move forward with the different ideas for we're talking about tax reform?
I did raise the issue with Ways and Means in that we were trying to get an appointment with staff down there. I finally got a call from somebody there. It was a gentleman, and I'm sorry, I don't remember his name off the top of my head, who basically said, mark it up, we'll look at it. So that was the response.
All right, well, any response you do get back, I'd like to know about them.
I am going to, when I'm coming back up here in May, I am going to try to get back to Ways and Means and to Appropriations and see, and try to run all the traps on that.
Okay.
And Mr. Chairman, it may not be the best idea in the world, maybe something that's
an idea,
but it's a place to start. And one of the things that we proposed in our written testimony is that it be dedicated. We would take a presidential finding of necessity and 2/3 concurrence of both houses of Congress to use it for anything else. Unless we have an alien invasion, I don't think we get 2/3 of the Congress to agree on too much.
That's true.
But I do appreciate it. If I can just beg your indulgence for 10 more seconds. Congresswoman Stefanik did introduce a bill, or a resolution rather, to show the sense of Congress that the original Agent Orange Act would have encompassed the bays, harbors, territorial seas. Senator Grassley, who was on that bill originally when he was in the House, put out a press release saying basically that's what we thought it was. So when the VA says they're confused, they shouldn't be. Thank you.
All right, thank you. Did you?
The tax cut and several after that first tax cut in the early aughts, if you will, upset many of us because it had never happened before in wartime. And to send the American people to the mall while our military went to war was setting up almost what happened to us as Vietnam vets. It wasn't the whole nation pulling together to go to the war. In fact, the seeds of all of our fiscal problems of our federal government were laid in 1966 with the Federal Unified Consolidated Budget Act, where they took the trust out of the trusts, Highway Trust, FUTA, et cetera, and then started appropriating it out in order to paper balance the budget. So the Guns and Butter decision was that particular piece of legislation, which has affected everything since because of the deficit and because of the scrambling. That's why people call it smoke and mirrors. I couldn't get anybody to introduce it, that you could keep the tax cut if you had a veteran who served on active duty in your immediate family. Otherwise, you couldn't have the tax cut. And that would distribute at least somewhat the pain, because it is the same, I'm convinced, same 1,000, 2,000 families that have fought every doggone war we've ever had, and that's certainly those in the combat MOSs.
Yeah. I'd like to turn it over to Ms. Estes.
Thank you very much. And I just want to say thank you. Thank you to all of you for your service. Urge you to continue to work with us. I think we all have good intent here, but to figure out how to do this in the challenging time, we really are going to need to work together. So finding where we can get those offsets, finding where we can get savings, finding where we can be more rapid in determination. And I want to thank the VA for staying. I know in our last hearing, folks were not able to stay. It's really important that we all be at the table together, that everyone listen to what everyone else is saying, and I want to thank you for staying, because we really do need all of us to be partners in this endeavor to do right by those who have served this country. So again, I want to thank you all very much. I've kept mine under 3 minutes. The only.
That's great.
Thank you.
Mr. Saban? Okay. That being said, we want to go ahead and release the third and final panel. And I want to thank everyone for joining us here today and sharing your views with the subcommittee. Your testimony provides us with important insight into the possibilities as we move forward through this legislation process. I ask unanimous consent that written statements provided by the Paralyzed Veterans of America and the Fleet Reserve Association be placed into the hearing record without objection. So ordered. Finally, I ask unanimous consent for all members have 5 legislative days to revise and extend their remarks and include extenuous material on any or all of the bills under consideration this afternoon, and without objection, so ordered. This hearing is now adjourned.